My name is Chiriel Tabusola. I am the Managing Director and Vice President of Government Affairs for the Restaurant Association of Metropolitan Washington, and it's a real pleasure to welcome everybody here today. Joining me today also is RMW Membership Specialist Layla Rose Galvin. She's co-hosting me today. She'll be running the chat, answering questions, and resolving any tech issues anybody might be having during today's webinar. I think the number one thing I hear from members has to do with workforce, and in particular, how do we bring people in, and especially the highly skilled workforce that's overseas, at a really challenging time, both within the industry domestically in terms of the workforce and larger, which really prompted today's webinar. We'll be looking at two things today. First, we're going to be looking at the potential impacts of the Essential Workers Act, and most importantly, then highest level, lesser known visa options available to restaurant operators. I'd like to thank longtime RMW allied member Grossman, Young, and Hammond for being here today. Hello, Becky, and welcome. And I'd also like to welcome Aaron Frazier. And Aaron is the Director of Healthcare and Tax Policy for the National Restaurant Association. We're really excited, like I said, to dive into the challenges as well as the opportunities that are on the table for us today. And with that, I'm going to turn my mic and camera off and learn along with everybody else. And welcome Aaron to kick us off.
Thank you so much, Jay. Everyone can hear me? Great. So as Jay mentioned, I'm Aaron Frazier with the National Restaurant Association. This is obviously a huge issue for restaurants, hospitality, and businesses all over the country, but particularly for restaurants. When we did our polling in terms of what is the biggest challenge right now for operators, and we put that in the field in the fourth quarter of 2019, so the last full calendar quarter before COVID. And the number one challenge was workforce and getting enough people to work in the restaurant. And then no less than 2 years later, it was back on top, saying, okay, it is still the biggest issue. It's not shutdowns. It's not access to capital. The biggest challenge is having a full team within our restaurant. As someone who's waited tables at 3 different restaurants in DC, I know that, they're in DC, certain times of the year just pop. Graduation from the colleges and Mother's Day, it's like brunch city, and you could make so much money as a server during those periods. I mean, I work Friday, Saturday, Sunday in those situations, but I remember parts of a restaurant having to close down because we had to shift everyone over to one area so they would not be available for dinner because they had such robust brunch. And that's really what this looks like, right? When we don't have enough people to staff our restaurants, you end up closing on certain days, closing early on certain nights, and just not being able to fulfill every last opportunity to drive revenue, to drive sales, and drive growth. So that's why this is so important. And we'll just jump right into the deck with our first slide. Again, the labor shortage is not a new thing, but according to our 2024 State of the Industry report, about 4 of 5 restaurant operators say that employee recruitment and retention is their top challenge. And 90% of those same people surveyed expect those challenges to persist or get worse in coming months. There's a lot of reasons why. We're not sociologists, we're not economists, but the worker participation rate in the economy is pretty low. Gig work is pretty high. And then less and less teenagers are going into the restaurant industry. That fills a key slice of time for us. So we really do have to look at things like building work visas, being able to attract people that want to come to the capital of the country and work for a summer, a winter, while they are also students at one of these great schools. Hey, I can also get a job and really get to know people as a bartender or as a cook or as a server. So the Essential Workers for Economic Advancement Act on the next slide really will fill a lot of those holes. Currently, there are visas specifically for the H-1B program for high skill jobs that require a college degree. But there's a big void in restaurants and other industries similar to us where positions don't require a college degree, but they're just as vital to the economy. They're Main Street jobs, they're small businesses, and it just makes sense that it shouldn't just be for tech workers in Silicon Valley or basketball players from Europe that get these really important visas, we should have them that benefits the economic engines of America. So when we looked at the Essential Workers for Economic Advancement Act, or EWEA, that creates a year-round visa program. We branded it as an H2C visa to address the needs of the industry. So it's a real solution that does not bypass American workers. You actually have to certify that there is a workforce shortage. It's just to make sure that we're not cutting hours, closing dining rooms. We want to ensure that we have a specific worker visa program that can address the worker shortage in our industry. Some of the key features of EWEA on the next slide. Some of those key features are the H2C visa program. It provides stability and flexibility for employers and employees. It's year round. And the visa is valid for about 36 months with 2 different renewals attached to it. So it lets workers to stay up to 9 years, which is a big deal for people that are still learning the country, learning their communities, learning their craft. It allows you to have some certainty across that time period. Also, the long-term employment. I mean, if you have a country, and there are a lot of them that have remittances as one of the primary economic contributors to their GDP. Like, it's great for everyone in our own continent, and especially as the border becomes more and more of an issue, saying, hey, here's a great way to make sure that we have access to job, access to employment, access to compensation that can help a lot of people back in their homes, back in their countries, so that we don't have those terrible immigration politics that tend to hoover up good ideas like this. So we kind of see it as a win-win on that issue as well. Now, I shouldn't have even said the I word. This is not about immigration. This is about worker visas. We get lumped into that big, scary discussion on immigration, but this is not that. When we really try to make sure people know this is about small businesses, this is about people who are able to work with temporary visas, and they're really, really important to address the high cost of constant recruitment and turnover in America's restaurants. So the visa is also portable after their first year, which allows workers to have more options and protections, and employers get a little more flexibility. So the portability of the visa means they can work for a different employer if they want to try their hand at culinary arts, if they want to try their hand at being a bartender, if they want to try their hand at fine dining, they can do that. They can migrate within the industry. And if the worker finds a better opportunity or the employer's needs change, the worker can do that to avoid stagnation. The agency in charge of the program would be the Department of Homeland Security. That really makes sure that there's compliance is a huge priority, because we want it to work really well. If we have our own program, it's got to be dynamic. It's got to be fully sealed up in terms of compliance, and that's really, really important to us. The next slide has the employer obligations under EWEA. Number one, the employer has to make good faith efforts to recruit U.S. workers before pursuing the H2C worker program. That is just, for me, I was like, okay, that's every restaurant in general. You don't have to put out a help wanted sign to need workers. I mean, that's kind of baked into the cake. The program is limited to regions or metropolitan statistical areas where the unemployment rate is below 7.9%. That ensures that U.S. workers are not displaced. Why that level? It's the unemployment rate is very seldom going to go above 8%. And that's something that we saw as kind of it was a barrier that we could step over real easily. The wages that are paid to H2C visa workers, they must meet those standards set by the Bureau of Labor Statistics or other local data, making sure that all the workers are paid fairly and in line with the local wage rates. And employers must also use E-Verify. That adds another layer of accountability. The E-Verify system is imperfect, but again, it provides one more layer of security for that employer that's accessing this program. Again, that would only be a hurdle if we are absolutely getting H2C visas, which I think would be manna from heaven. The next slide talks a little bit more about visa caps and the economic regulation. One key thing that makes H2C so effective is that it is an adjustable visa cap. For example, the first year that the program comes out, the initial visa cap is 65,000 workers. And I know what you might be thinking in the greater DC area, we might need half of that. We might need more than that, let alone what they're going to want in California, Texas, Florida, and up and down the mid-Atlantic. But we're starting slow. We want to make sure the program gets off to a good start, but that number can go up to 85,000 per year. And it can also go down to 45,000 a year. But if you're going to go up to 85,000, think about 80,000 temporary visas every year being added into the program. Over 10 years or under the first life of this program, that could be 800,000 work visa participants in this program. Again, they can stay for up to 9 years. So that's a different element to this program that we think makes it really effective, that we're going to start slow and then we're going to build something to last. The visa renewals, as I said, they don't count against the annual cap. So we get that influx and we keep the workers that we had in the previous year. And ultimately it's going to be adjusted by economic need. Let me stop there and see if there are any questions that we want to do now before we kind of move into the back end of my time here. All right, seeing none, I'm just gonna charge ahead. For the small business considerations, small businesses are really the focus of this legislation. The bigger companies, or they have programs already in play to access their share of different work visas, but at least 25% or more of the visas are going to be reserved specifically for small businesses that we know just don't usually have access to the same types of immigration attorneys and naturalization and recruitment that bigger businesses have. The small businesses that invest in safety and training programs or work through disadvantaged groups through things like the work opportunity tax credit receive priority access. So being a good actor and being a small business in your community is going to bump you up a little bit in the priority list. And just for folks who are not familiar with the work opportunity tax credit, I mean, I'm a tax guy, so I always have to plug this more, but the work opportunity credit is up to a $2,400 credit for any employer who hires someone from a population that faces traditional barriers to employment. And if you're thinking, well, what groups face traditional barriers to employment? These are ex-felons. These are people that are on government assistance, like SNAP benefits. Or these are people that are like a U.S. military veteran who has a disability. There are tax credits in place for when you hire that person. You make your filing with the Department of Labor, either at the DC level or at the state level, and you make your filing with them. You say, hey, I hired someone from this background, and you are eligible for a federal tax credit under WOTC. So small businesses can hire any of these workers. And now we're going back to H2CE programs, our proposal under OEA. You can access these workers who are eligible for portability, even if they don't directly bring in new H2C workers. It's like a college transfer portal. They get more flexibility in how they manage their workforce. And on my last slide, we are continuing to urge Congress to say, you have to address the workforce shortage that is only getting more and more severe every year. We have a bill that's bipartisan from Congressman Lloyd Smucker and Congressman Henry Cuellar from Texas. The bill number, if you want to track it or just plug it into your phone for a Google alert, is HR 3734. We're not asking for a handout with this bill. We're asking for a solution. This is really going to build a great workforce program over the long term. To shake this loose, to really advance this, we think that we're going to have to be a part of a bigger moment. If it's President-elect Kamala Harris or President-elect Donald Trump, we need to go to them and say, as if you are going to make good faith efforts to address the asylum system, to address border security, to address Dreamers and DACA, people that are affected by the deferred action, you need to include this in that package that you're going to address. Or we're just going to look at an economic and workforce perspective and saying, how do we address the gulf between the workers we need and what we currently have right now for worker participation? This is going to be a key consideration of it. So we're looking for a ride on a bigger vehicle because it's not going to pass on its own, but we're doing all the things. We're building that infrastructure right now. This is part of that infrastructure, having Che lead this discussion and making sure that more and more people are interested in this, engaged on this, and hopefully you can also educate people in your community about why this is so important and how this has to go hand in hand with long-term workforce improvements. But with that, I'm happy to hand it over to Becky.
Thank you, Aaron. I really want to underscore how wonderful this legislation is. It's really a very practical solution to a very big problem, one of the biggest ones that our country faces, in my opinion, which is the mismatch between unfilled jobs and available labor. So I think this is a fantastic bill, and it's bipartisan, which we don't always see in this arena. So please do what you can to support it. Let me start by introducing myself and my law firm. So I am an immigration attorney. I've been in this field for about 30 years. My firm is Grossman, Young and Hammond. We're located in the DMV, and we do all areas of immigration, from employment-based immigration to family-based immigration, deportation, removal, etc. But my own love is working with clients in the hospitality industry, and I've been doing that for almost my whole career. I represent many RAMW members and restaurants across the country, and that's really what I love to do most. So what we had decided to talk about today are lesser known options for hospitality workers. So focusing on essential workers in hospitality. A lot of times, as Aaron mentioned, when you hear about visas, you hear about H-1B, which is for people who have a bachelor's degree, or other options for skilled workers. And when we talk about, when the conversation goes to essential workers, so jobs that don't necessarily require any level of education and little or no experience, those conversations often turn to the J-1 visa, which is a training visa for young folks, as well as the H-2B visa, which is a temporary visa largely for seasonal positions. So we can touch briefly on those, but I also wanted to let you know about some other options that you may not know about or may not have thought about. And I would also make the offer, if anyone on this call is an RAMW member, we do offer a courtesy consultation if you're interested in these topics and you want to explore them further. So Christina, if you can show us the first topic, which is the H-2B visa. So you may know about this visa. It is for a position that lasts less than 1 year. And like the H-2C that Aaron was talking about, you do need to show that US workers are not available. And so this requires doing a test of the labor market. For businesses that need to employ a lot of workers, and again, it is typically on a seasonal basis, but it also could be a one-time or a peak load need. This visa makes sense if you're bringing a lot of workers, like a ski resort or a swim club, but are some examples. We have done these visas when there's just one worker involved, but it's honestly, in my opinion, not worth the investment. It's a pretty cumbersome process, and if you are doing a lot of workers, you will realize economies of scale, and that might make sense. But the H-2B is not my favorite visa for many reasons. And so we're going to move to the next slide and talk about other options. So the H-3 trainee visa is one that we use from time to time. I think the most important thing to understand about this visa is that it is not for productive employment. So this doesn't necessarily help to fill positions such as, bussers or dishwashers, but it can in certain circumstances be used. We have used it in the restaurant industry, and it's for a training opportunity that is not in the normal operation of the business, so supernumerary, and not a position in which US citizens or resident workers are regularly employed, and you can only engage in productive employment if it's incidental and necessary to the training. You also have to show that the training will benefit the person in pursuing a career in their home country. So that can be easier to do if the restaurant in the US is doing something that's very unique. Could be a celebrity chef. It could be that they have some very unique model of operations that maybe doesn't exist in the trainee's home country. Maybe you are thinking about opening a branch of your restaurant in a different country and you want to bring someone from that country to learn about how your restaurant operates in the US. And then you want to send that person back to the home country to help set up the restaurant. So that's sort of a textbook H3 case, and we've definitely done that type of case before. You do have to show that the person will somehow use what they're learning in the US when they return to their home country. So this visa option is not, the answer to all of your prayers, but in certain solutions, it can be a good solution. And we have used it for many clients in the hospitality industry. It's similar to the J1 visa, if you are familiar with that visa, in that it tends to be for younger people. And you do have to show that it's a training opportunity. So you have to show what the person is learning. So that's a basic intro to the H3 visa. The next visa that I would like to talk about is the P3 visa, which is for cultural performers. And this is one that until recently we had not used in the hospitality industry, but we have been using it with some success. It really applies to situations where the restaurant is doing something that's unique to a particular culture. And although I suppose you could say the United States has a particular culture in this context, I would not try to do this for an American restaurant. But and also it's important that the restaurant is focused on a specific culture. So if you are a Pan-Asian restaurant, this is probably not going to work for you. If you're a continental restaurant, this is probably not going to work for you. On the other hand, if you are a Brazilian steakhouse or a traditional Japanese restaurant or a Peruvian restaurant, and you are bringing that country's culture to the United States through your food, this could be an option to consider. So like all of the options that we're talking about today, it doesn't require any particular amount of experience. It doesn't require any education, although education doesn't hurt, but it's not required. But what you have to show is that you do have a background in the culture that you are presenting. And what I find interesting about this category is that it doesn't actually have to be your own culture. So for example, we did an Italian opera singer or a performer of Italian opera who was from Spain. So it doesn't matter your nationality, it matters that you have expertise in a particular culture. So if you do operate a restaurant that is focused in a particular culture, this is a worthwhile visa to consider. The P3, so that going back, you don't need to go back in the slides, Christina, but just referencing back to the H3, that's available for a maximum of 2 years. The P3 is available in 1-year increments, but it can be renewed indefinitely. So although it's kind of a pain to have to renew it every year, you can keep someone here really in the long term on a P3 visa. So very interesting visa to consider for restaurants that are presenting a specific culture. Let's see what's next. Next is L1B specialized knowledge workers. So this is a visa that's relevant to restaurants that are multinational. So that may not apply to many RMW members if you're, if you have a single unit or if you're a US-based company only. But if you do have a parent, branch, subsidiary, or affiliate restaurant outside the US, you can transfer workers back and forth between that restaurant and the US. And a lot of times these workers would be managerial level workers. Those do require more education and experience than, we would think of for an essential worker. But what we want to focus on today are visas for L1B specialized knowledge workers. So these are workers who have a particular type of knowledge that is unique. Doesn't have to be proprietary, but it often is proprietary about the way that a restaurant works. And I think the most interesting example of an L1B being used in the restaurant industry is the Fogo de Chao case. So some of you may be familiar with this case if you've been around for a while. So Fogo de Chao is a Brazilian steakhouse, and they were bringing folks from Brazil. They were based in Brazil. They opened a U.S. branch or subsidiary. They were bringing folks on the L1B visa, and they were arguing that what these individuals had learned by growing up in their native culture in Brazil, so not through school, not through any particular work experience, but just through their cultural experience of living in Brazil, that they would qualify for the L1B visa. And in fact, Fogo de Chao had gotten many workers approved in the L1B category. And then something that often happens with USCIS, all of a sudden USCIS decided that they didn't like that argument, and they started denying these L1B visas. So Fogo de Chao sued them in federal court, and the case went up and down and around in circles. But ultimately, the last thing that happened in this case was that the federal court ruled that in favor of Fogo de Chao, saying that culturally acquired knowledge could potentially count for L1B purposes. And there is now a memo that was put out by the Immigration Service that incorporates this concept into the law of L1Bs. So immigration law is kind of strange. It doesn't always exist in the law book. Sometimes it exists in the form of memos, but this is a very interesting memo that really formalizes this Fogo de Chao guidance. And so if your restaurant does have affiliates overseas, this L1B category could be an interesting possibility to think about for transferring essential workers. Okay, here's an interesting one. So this one, I think that the first four that we talked about are more common, and many of you may have heard of them, maybe not, but that this next one I think is a much more unusual category, but particularly in Washington, D.C., this does come into play. And so I wanted to mention it just because I think it's very interesting. So the B1 visa is a business visitor visa. So if you want to come to the U.S. as a business visitor, for example, if you work for Fogo de Chao Corporate and you want to come to the U.S. for a business meeting, you could come on a B1 visa. But there are a whole bunch of exceptions and special types of B1 status that are really interesting. And one of them is the exception for domestic workers. So not everybody can sponsor a domestic worker. Interestingly, a U.S. citizen like myself who lives permanently in the U.S. cannot sponsor a domestic worker on a B visa. Also, someone with a green card cannot sponsor a domestic worker on a B visa. So who can sponsor a domestic worker on a B visa? The first category is U.S. citizens living abroad, habitually living abroad, or temporarily assigned to the U.S. So basically, if you have lived overseas for most of your life, but you're coming back to the U.S. for a few years, maybe to care for an elderly parent, and you want to bring your house cleaner with you, or your private chef, which is a fact pattern that we've seen, you can do that. So U.S. citizens who are not habitually residing in the United States can sponsor housekeepers, chefs, and any other domestic workers. Then the second one are foreign nationals in the U.S. on a temporary visa. So if you look at the visas we just talked about, those individuals can actually also bring private chefs, house cleaners, et cetera, to the U.S. with a B visa. It does require that the sponsored worker has 1 year of experience in the offered job. So it's not a no experience type of category, but it is a fairly minimal requirement that most applicants in this situation can meet. And so the process for this visa is done directly at the consulate in the country where the domestic worker is residing. So this is a relatively fast and easy way to get work authorization. Again, that this may not be super relevant in the restaurant industry, but I mention it just because it does apply to private chefs, and we do sometimes work with hospitality industry clients who may utilize this category. Okay, so I'm going to stop for a moment and see whether we have any questions. Layla Rose, are there any questions that we need to address at this time? I see here we have experience with the J1 and internship and training program. So let me address that question. We utilize the J1 category frequently. And the thing to know about the J1 category is that it does require working with a training program sponsor. So these are private organizations that are designated by the Department of State to oversee J1 training. So our law firm helps clients to get J1 visas, but we always work with a J1 sponsor. Restaurants can also work directly with a J1 sponsor, and many do. So if that's something that you're interested in doing, we help our restaurant clients. Sometimes, for example, different J1 sponsors have different rules. So some of them will not accept people over the age of 35. One of them won't process anyone from India. I know, Aaron, it's so sad. One of them will not process anyone who's not in a fine dining restaurant. So each sponsor there are several hundred sponsors. Each sponsor has its own weird rules, and because we do a lot of J1s for clients in the hospitality industry, we can often find you a sponsor. If you tried to get a J1 with your regular sponsor and that sponsor said no, we might be able to find you a new sponsor. If you don't want to bother trying to figure out which sponsor's rules you can comply with, we can help with that. And we also help to facilitate the process, preparing the individual for their interview to make sure that they don't go in there. For example, the J1's a training visa. If you go to the embassy and say, I'm coming to work, and by the way, I'm going to live in the US for the rest of my life, you're not going to get the visa. So we have a call with the foreign national before their interview to make sure that they understand, what they should and should not say during the interview. And so we do have a really high success rate with J1 visas. I actually love the J1 visa. The J1 trainee visa requires either a bachelor's degree and, a university degree. It could be an associate's degree, an associate's or higher degree, and 1 year of restaurant experience or 5 years of restaurant experience. And then the intern visa is for current university students or university students who graduated within the last year. So for that segment of the population, that is always, as an immigration lawyer, the very first place I will go. If a hospitality client calls me and says, I want to sponsor this person, I'm going to look at the J1. The J1 is faster, it's cheaper, it's easier than any of these options that we're discussing. And I think it's a great visa. It only, in the restaurant industry, brings the person here for 1 year, and it can't be extended. You cannot bring people here on a J1 with the intent of keeping them for longer than 1 year. However, if somebody comes here for a 1 year visa and at some point you decide that you would like them to stay longer, it is legally possible to look at other options, such as the ones we're discussing, and other choices. But other future sponsorship is available for individuals in the J1. But again, if they start the process by telling the consular officer that's what they're going to do, they're not going to get a visa, but intent could change during the course of being in the United States. So the J1, I definitely would give a thumbs up to that category.
Much appreciated, Becky. Thank you.
My pleasure. So Christina, if we can turn back to the presentation. So all of the options we've talked about so far are employer sponsored. So that requires a specific employer to fill out paperwork to sponsor the worker. I also wanted to mention a few options that are not sponsored. So sometimes workers will come to you and they already have their own work authorization. And by the way, if anyone comes to you with any of work authorization in the categories we just discussed, an H-2B, a J-1, an H3, a P3, an L1, and it doesn't have your company's name on it, they're not authorized to work for you. So we do see that sometimes the person will present a valid work authorization where the dates are valid, but it's for another employer, and then our client will hire that person and employ them, but that's a problem. So if it is an employer-specific work authorization, you need to be the specific employer that sponsored it. However, these are a few options that provide unrestricted work authorization that employees can get on their own. So the first are refugees and asylees. So those are individuals who've already been granted refugee or asylee status. And one important thing to understand about the terms refugees and asylees, so both of these are people who fear persecution in their home country based on specific grounds, such as political persecution or religion or ethnicity. Refugees are individuals who are outside the United States and who are admitted to the United States through a special program based on that fear of persecution. Asylees are people who are inside the United States who are granted status. So if you're in the US, you can't apply as a refugee, and if you're outside the US, you can't apply as an asylee. And often we do get asked, how can I apply for asylum if I'm outside the US? The answer is you can't. If you're outside the US, you have to be classified as a refugee, and that's a very difficult process, as we'll talk about at the end of this presentation. But if you are in the US, you could apply for asylee status. So once you're granted that status, you will have unrestricted work authorization. The other category of related individuals who gets unrestricted work authorization are asylum applicants. So not immediately, but when you apply for asylum, there's a 150-day clock after which you can apply for work authorization, and then that it takes however long it takes USCIS to give you the work authorization. So asylum applicants are eligible to apply for their own work authorization, but only after a specific period of time. The next category of people who are authorized are E, L, and H4 spouses. So E visas are given to E1 visas are treaty traders. So for example, I once represented a coffee importer, and that coffee importer utilized the E visa category. So if any workers came to the US to work for that coffee company, their spouses could have work authorization. And that's automatic. They don't even need an employment authorization card, which is the image that you see on this page. They just are authorized from the minute they set foot in the United States. The same with L. So we talked about the L1B category a little bit earlier. If you were to sponsor an L1B worker to come to the United States and that person was married, their spouse would have work authorization unrestricted immediately upon entering the US. Also, certain H4 workers only, which are dependents of H1Bs, only if the principal spouse had made it to a certain point in the green card process. And then the last one are spouses and kids. And I mentioned this because we're in Washington, D.C., of diplomats and international organization employees. So anyone who's working for an embassy or a World Bank, their spouses and kids often have work authorization. There are some exceptions. J1 exchange visitors. So if you hire a J1, that person's spouse is eligible to apply for employment authorization, and also people in the green card process. So with a few exceptions that I mentioned, the E and L, all of the workers in this category will have an employment authorization card. And that is enough. If a person presents that card to you, that's enough for them to be authorized to work in the United States. So this is just good to keep in mind that especially in Washington, D.C., there are a lot of people in these categories that do possess unrestricted work authorization. Okay, so that concludes temporary options. We're just going to cover briefly some permanent options, so immigration options. And the first is the basic process, or PERM, labor certification, which is a 3-step process that requires you to show, just like for the H-2B visa, also the H-2C proposed visa that Aaron talked about, to do a test of the labor market. So the good thing to know about PERM is that you don't have to require any education or experience for a PERM. And typically what we will see if we get a client who comes to us and they want to do a PERM application, they will want to put all, they'll say, okay, we want to hire a server and we want this person to have 15 years of experience as a server and a master's degree in restaurant management, right? Because they want to make it as difficult as possible. But the reality is that's not a great strategy for a PERM case. And because you're in an industry where there's a genuine and documented labor shortage, there's really no need to try to fluff up your PERM application. And, we've seen many successful cases. If you file a PERM for a job that requires 0 education and 0 experience, and nobody applies for that job, you just won your PERM. I mean, you still have to jump through the hoops, but the point of the PERM is to show that there are no workers available. So a lot of the jobs that are being offered in the restaurant industry, there really are no workers available for them. So people will often come to me and say, like, I heard it's really hard to do a PERM. How are we going to prove that, that there are no US workers available? That's usually the easiest part of the PERM in the current labor market, particularly for restaurant jobs. So the PERM process involves this test of the labor market, then an immigrant visa petition where you have to show that your restaurant has the ability to pay the person. So as long as your restaurant is profitable, that part is usually straightforward. And then the final step is the application for adjustment of status. So altogether, this process is currently taking about 3 to 4 years. So it's not a quick process. That's why we talked about some other options that are short term, but it is a great option for sponsorship. And I guess one thing that I should mention that maybe I should have mentioned earlier is that these are all options for legal immigration. So a lot of the workers in the restaurant industry who are currently here who have overstayed are probably not eligible for these options that we're talking about. We do assess them on a case-by-case basis to see what's possible. But if you have an inadmissibility issue, so if you have a criminal issue or an overstay of more than 3 years, of more than 6 months, which makes you subject to a 3-year bar, then you are likely not eligible for these options. So that, I apologize, that's a really important point I probably should have made at the outset. So we are talking about legal pathways for individuals who are not inadmissible to the United States. One of my biggest hopes is that the DHS will do away with the 3 and 10-year bars. In my opinion, that's one of the biggest barriers to actually solving the problem of immigration in our country. But while those 3 and 10-year bars exist, they do create an issue for many individuals who are currently in the US and undocumented. So with that, I would like to move to the final slide, which is about, and let me see here if we can, okay, which is about an interesting program that I actually just learned about recently. So this program, Welcome Corps, allows individual US citizens to sponsor individual refugees. And we've placed the link to the program here. We did speak to the sponsors of this program recently to learn more about it. It sounds like it is, again, maybe not the answer to all of our dreams. It's moving along at a slow pace, but it is an option that's very interesting. So people are always asking me, how can I sponsor a refugee to come work for my restaurant? Like really good-hearted restaurant operators, when they hear about The crisis in Syria, when they hear about the crisis in Afghanistan, Ukraine, I always get lots of calls saying, how can I help? And I would really like to sponsor a worker. And I have always told them the answer is you can't, because traditionally the refugee process is not something in which private citizens can really get involved. It's handled by agencies like the UNHCR, and it's really sort of out of our control. But Welcome Corps, I would encourage you to take a look at this link if you're interested. It is a really great program that I hope will, get rolling and take off. And I think that it has a lot of potential to enable us to tap into this market of workers, which, it's just one of the pools of foreign laborers. There are so many people overseas that would love to come and work in the United States, and so many US employers that would love to employ those individuals. I feel like my role as an immigration lawyer is at least partially to be a bridge between those two groups and try to see if there are solutions, such as the wonderful legislation that Aaron talked about at the beginning of this presentation, ways to bridge that gap and provide US employers with the labor, with willing and available labor. So that concludes everything that I wanted to share with you guys today. And if there are any other questions, feel free to share them in the chat or just unmute yourself and ask the question. We would be happy, Aaron and I would both be happy to answer any questions you may have.
Thank you, Becky. And I would like to repeat that anybody who has any questions, please drop them in the chat, raise your hand. Now's your opportunity.
Becky, I want to say thank you, and thank you, Chair, for organizing this. This is super helpful, and we're definitely looking forward to chatting with you in person as well. We'll schedule the consultation. We have quite a few questions that I think we can, work together on. So
Wonderful.
appreciate this.
I look forward to meeting you.
Yes, absolutely. Me as well. Thank you very much.
Thanks, yours. Other questions, other comments right now? Well, before I wrap up, any closing comments, Aaron, anything you want to add?
Just thank you for being on today. And I think Becky's information is that operational knowledge of the how that is so important, because even if we hit the half court basketball shot and get H2C in there, you're still going to need to know the infrastructure, the pathways to bring people in on these visa programs. And I think that's such an incredible infrastructure that you can build out right now with Becky. So I was glad to be on it and learn something as well today too. Thank you.
Thanks, Aaron. Becky, any closing comments before we send everyone off?
Just a big thanks to everyone who joined, and feel free to reach out if you do have follow-up questions and would like a consultation.
Sorry, there is one question in the chat from Anna. Is there a timeline on EWEA? Okay,
yeah, I misspelled a word there, but it's not going to happen this year. Things generally happen more in the first year of a new presidential administration. They just went through a grueling campaign. There's definitely an appetite to do things on the immigration front and on the workforce front. So I think depending on what's going to be happening, what the temperature of the country is, I would say the best shot at getting something done is the first 18 months between January 2025 and summer 2026. That's when things are going to happen one way or the other. But there's no timeline in terms of we expect EWEA and H2Cs to be in place this year or next year. But we have to be poised and ready for our moment in the next 18 months, beginning in January.
And Aaron, a follow-up to that, this would likely be part of a larger immigration bill. This wouldn't be a standalone, correct?
Exactly correct, Shay. It's going to either be on the workforce train, and we have to do something to improve workforce rates in our country and address the worker shortfall that is predominant throughout the Western world. And then we have to have that or that second bucket of saying we have to do something because of Dreamers and DACA and fixing asylum system and sealing the border. We have to do something in that category. We're much more comfortable in the workforce bucket because that's where this belongs. But if there is something you're going to say, hey, the adults in the room are going to stand up and actually address some of the bigger ticket immigration problems that we have, then we definitely are going to be part of that conversation.
And we will be there advocating alongside you as always. So thank you, Aaron. Thank you, Becky. Let me highlight a couple upcoming events for attendees here. Everybody in DC, next Wednesday at 4 p.m., we are hosting a legislative reception for Council Member Robert White at Cork on 14th Street. Also like to highlight October 22nd in the happy hour time period, we'll be hosting our fall member meetup. Invite everyone to join us, including prospective members. It's a great time to connect, meet with one another, commiserate with one another when needed, but also the great opportunities also for peer learning. And then on March 19th, 2025 will be the RMW annual meeting. Immigration will likely be a topic, among others, that we'll be discussing on that day. That will be at the National Landing Experience Center. Tickets aren't on sale yet, but we hope everybody can make that. This year's annual meeting was a great event, and next year should be even better. So once again, thank you, Becky Grossman Young. Thank you, Aaron and the National Association. Thanks to everybody for joining us. If you get the weekly message, you can look for a recording of this webinar to be shared in a future weekly message. You can share that with individuals who may have missed this. And then we'll also have a one-pager coming out with some of these detailed visas that Becky had walked us through that can kind of act as a quick resource guide. Once again, my name's Che at the RMW, and thanks for joining us. Everybody enjoy the rest of the cloudy, rainy-ish afternoon, and we will see you next time. Bye-bye, everyone.
See you soon. Bye.
Thank you.